Hey criminal justice students, it's Mr. Johnson, another criminal justice video. Today I'm going to try to make it quite short. I know I say that and I have no idea how that turns out, but bear with me. At the time I'm making this, I think it's going to be on the shorter side of videos. I don't have as much side stuff. It's going to be short and sweet, but the things are, you really need to write some of this down or keep track of it because it will affect you later in life, or hopefully doesn't once again, but it might. But first, of course, a joke. A priest, a minister, and a rabbit go to give blood. And the priest walks up and says, I have AB negative. And they say, okay, cool. And they take him in. And then the minister comes up and she says, I have B negative. And they say, oh, okay, cool. And the rabbit comes in and says, I think I'm a type O. Yeah. All right. Today, policing and the rule of law. So the first thing to know about policing is the role of a warrant, because getting a warrant is probably one of the most important parts of conducting police work in terms of investigation and stopping of crime. A warrant is an order from a court that directs police to search a specific place or property at a certain time with a specific reason. The police, in going to court, must prove there's a probable cause to believe a crime has or will be committed. What is reasonable is that their information is reliable and enough for a probable cause threshold. And there's been a lot of debate as to what counts as probable cause. Nothing is really defined that way. So yes, the Constitution says with probable cause, but what is probable cause to get a warrant? So a warrant is issued usually by a magistrate, and it includes some affidavits, which are sworn statements suggesting that what they are saying is true. And secondly, the idea has to be that it's objective, it's reasonable, and reliable information. And so it gets into, once again, what do all of these things mean? So what is particularity? So what that means is it's specific to a search. What are you searching? Now, let me give you an example, and we're going to continue this example of, let's say someone wants to search stuff in my filing cabinet. And so the police have to say they are looking for, okay, I've never done an illegal drug, so there's that. Let's say they're searching for a couple kilograms of cocaine. Okay, like Mr. Johnson's going big or going home. You know, let's just, I know, sorry. No, I don't do that. Okay, so, but when the police are asking for a warrant, their suggestion is that the warrant is specific to my filing cabinet inside my classroom, that they'll find it there at this particular time when they want to search, at this date and place. And so because of all that information, they could obtain a warrant if they have probable cause. What constitutes that as probable cause? Where are they getting their sources? One of y'all could have snitched. No, I'm just kidding. You should report criminal activity like that. So it could have been a student saw Mr. Johnson open up something and it looked like a huge bag of packed powder, which was interesting for a school teacher. So the student might see something suspicious, and then of course the teachers all notice Mr. Johnson rolling in with a brand new, Lexus, just chill and be like, hey, everyone, and that's just interchangeable with his new Porsche too, because, the teacher's salary can afford all of that. So that's suspicious. Then student had that. So they look at the informant. How does that informant know that information? Let's say that informant is one of my student aides who said they were going back to grab something that I asked them to get, and they noticed that the drawer was open and there was some stuff that looked very suspicious. So in that description of that explanation, there's a reasonable understanding that what they saw could have been criminal. And because of that, then, that's enough to suggest it's probable cause. That's if the person did not go anonymously, because we'll get into that in a second. So looking at sources, is it a co-conspirator? Is it someone that's realizing that, hey, I got caught, let's say it's me and, let's see, who's a teacher? I can't think. Mr. Knoll. Sorry, that came really quickly. Well, let's say it's me and him that have been working on this, and y'all pinch me, but Mr. Knoll's really the mastermind. So they're trying to obtain a warrant for Mr. Knoll's car, and sure enough, I'm giving them all the information of what Mr. Knoll's doing. Why am I doing that, though? I'm looking at a reduced sentence. So my reliability is in question because I'll say anything to not have as much of a sentence or get off. I might be able to say, hey, look, I'll take immunity if we all go after Mr. Knoll. So that's how that might work. Was it a victim? Was it a witness to a crime? These people matter in how they obtain their information. There are informants and criminal informants that inform to the police certain criminal activity, but their word alone is not enough to get a warrant. Police still have to do some basic investigation and following up. And so they can walk up and look around, and if the place looks suspicious enough or a little bit sketchy and they're following a pattern that was described by the informant, that might be enough to suggest overall there is a level of suspicion that meets the probable cause, that this is fitting a standard. Other things that are needed to corroborate is hard evidence. Likelihood the informant is telling the truth, and in many cases, the question comes about, how does the informant even know this? If they're not the criminal one, how does some cellmate know about this guy's criminal activity or what they've been up to? And so anonymous tips are not enough. The person must be able to prove credibly who that is. It depends on how credible what their testimony is. There have been cases where an anonymous tip that outlined everything in this one particular case, enough that the cops suggested that this is worth investigation and a probable cause, and a warrant was issued, found, and everything went through. Now, that doesn't mean if you see a bunch of kids at a bus stop and you say those kids all look suspicious, one of them probably has a gun, and call the police. And even if you did know they had a gun, and the police walk up and see a bunch of kids stand together, and they said, we're going to search you all and find a gun, and boom, that's it. That isn't it. That's still not enough because the police did not independently verify the information. What's so suspicious about a bunch of kids standing around talking to one another? I mean, maybe with the quarantine, that'd be off. It has to be sufficient enough to show knowledge or understanding. And so with that, that's why anonymous tips are just not enough. It's got to be a whole level of understanding, a whole level of probable cause to bring up to that suspicion. That's a warrant search, but there are warrantless searches that are allowed. And a lot of times it has to do with immediate or exigent is what it's called, or emergency situations. So the threshold inquiry is a reasonable suspicion to stop and frisk. Stop and frisk is one of the most common ways of policing, is if someone is reasonably suspicious that they can authorize a stop. So a stop is a brief detention of a suspect or suspicious person used to determine whether a crime has been committed or probably could be committed. The frisk is a pat down for the protection of the officer to make sure no one's armed. Now, the issue with that, though, is when they pat you down and they find something, that's their evidence. If it's an illegal gun, it's a legal gun. If they pat you down and find drugs, that's admissible. Even if it's in your pocket, you're like, I didn't have a gun on me, doesn't matter. They can still search you for the protection of the officer. And if they find in the search a pat down for their protection that you are carrying something illegal, that is still defined, and that's called a Terry stop or a search. Now, here's the thing. What is suspicious? What is not suspicious? So the police are driving down a highway or a main road of this city, and there are no narcotics officers. A person walking in a high crime area sees the police, turns and runs. Police chase him down, stop him, search him, and find that he's carrying drugs. He argues there was nothing suspicious about him running, but the Supreme Court ruled that looking at the whole situation, the highly trafficked area, the running from the police, those things add up to being suspicious, and enough things go together to cause a reasonable suspicion. Now, there's other rules as well, called search incident to a lawful arrest. So if you're being arrested for something, they can search your immediate vicinity. First and foremost is for the police protection. So if you're getting arrested from your car, they can search everything around your car. Oh, shoot, I'm getting ahead. There's auto searchers in a second. You can be searched wherever you are at the time of an arrest being made. Now, going back to my situation, let's say they find what they were looking for and they arrest me. Well, they can now search my classroom. And we'll get into whether or not they can even search my classroom in the first place. They can always search my classroom because it's considered public property. So that's different. But If they arrest me in my living room, they can't go into my dining room looking for drugs. If they search and find illegal substances in my living room, then they could say we have reason. We don't even have probable cause anymore. We got evidence. So now they can search the house because there's evidence on the premises that they can find. That's one thing. However, they can't just search around into locked stuff if they don't find anything. So let's say I'm hiding it, inside my television. They can't just smash my TV because I got arrested in front of them. So there's some other issues. Auto searches. In Carroll versus U.S., cars can be searched with probable cause. Because they're on public property, roads, they are subject to search. And the question then comes up, how much of the car can we search in a legal car search? Basically, they can search wherever the immediate vicinity of the person in the car. So they can search your glove compartment. They can search anywhere that is reachable by the driver, they can search. If it's just a regular car stop, if you're speeding and they do it. They cannot just pop the trunk for no reason. So we'll get into some other ones in a second. What about a roadblock? Can they stop you at a roadblock? And yes, they can. With random stops, it's illegal, but there must be some suspicion. So if Courthouse Road has had a series of drunk driving incidents, and so the police put up a barrier or a checkpoint for sobriety, that's lawful. There's suspicious behavior going on, and they're trying to curb that as part of their job. There are other ones that are uniform ones. So they're purposely putting in specific places for that, and those are perfectly legal, where they can stop any car going along that road. Now, let's say you're going a few miles over the limit, like everyone does while driving, and you get pulled over, and the cop asks you to step out of the car and start searching your area around you. You have a passenger. Can they search your passenger? Yep. Once again, the point is for officer safety. And so in the defense of officer safety, they can search all people in the car at a lawful stop. The other situation they said is, what about if the cops pulling me over for a broken taillight and then searching my whole car? Well, yes. Once you have a legal stop made, especially if it's a moving violation or any kind of violation on the car, they can stop you for whatever reason and search however they need, only in their safety. They have to have probable cause to start searching your car. So pulling you over for a minor infraction to look for other things, that is called a pretext stop, and those are also legal. Another fact for you guys to learn: anything in your car, if you're the driver, is yours, unless someone else claims it or it can be proven to be theirs. So your friend's purse, that's obviously hers. But 2 backpacks in the back with no ID inside of them, they're all the driver. So you're responsible for the passengers you keep and the goods inside of there. Now, giving consent to an officer. A lot of people think that they have to give consent to an officer when they ask if they could search something. You don't. You do not have to give them any consent. In fact, you cannot feel in any way coerced into that. A police officer could say, can we search your car? I mean, we're going to get a warrant anyway. It's just a matter of time. You tell them, then get a warrant, because they can only search if you give them consent in the moment. So it has to be freely given without coercion. So, can we search your car? You're looking at a $150 fine. That's coercion. And it has to be done intelligently with all the information gathered. So that gets into some things, because the police do not have to tell you you are free to go from a stop. So ask that. Ask, are you free to go? If you ask them that, then they do have to tell you. But if they're like, hey, we got you for a 75 and a 65 or something, and, slow down. Can we search your car? You can say, am I free to go? That's the kind of things you need to look out for. Now, the police can also get on a bus and search the people on the bus. Now, there's other rules to what they can warrantless search. And one of them is called plain view doctrine. So one of the deputies is walking through the parking lot and notices a blanket and an outline of a handgun. underneath the blanket. That's enough. That's probable cause that there's a gun on the premises and can search. So what's in plain view or can be easily seen gives probable cause. Now, your curtilage is the term, and it's basically your property and everything around your house. If it's an open area, it's also subject to search. So we're talking about, it's other ways calling it open fields or plain fields, is basically if it can be seen, it's subject to search. The police can fly a drone over your property and look for stuff in the backyard if they have to. That's all legal. Your trash is also considered legally able to be searched. Once you put your trash on the street corner, be thrown away, you are basically relinquishing your rights of privacy to it. And that's one of the things to understand is what is your right to privacy. And just to go back with my example, in my filing cabinet, if I make sure no one goes into my filing cabinet and that's my space, and like, let's say a student walks over, then I'm like, don't you touch my stuff. And they don't, there's a reasonable expectation of privacy that what's in my filing cabinet stays that way. If you've noticed with me though, I've let people go into the filing cabinet of mine, my closet and drawers. Everything is open. So with that reasonable expectation, I don't have a reasonable expectation of privacy in those things because they're all open. But I do that on purpose as well because I don't want to hide anything. Other things about consent and search and evidence is recorded conversations. Virginia's a one-party consent rule. So if me and you are on the phone and I hit record, one party knew, that's it. Some states have two-party consent. That's why a lot of telemarketing, they say this call may be recorded for, quality assurance. It's really to make sure that in case something happens, you have it on record. But they inform you, so that's a two-way informed consent. Now, when I go back to reasonable expectation of privacy, there's one thing I want to go over is who has the reasonable expectation of privacy and who has legal access. So, can I let you into someone else's car, or can I let the police into someone else's car? No, I don't have, that's not mine. I don't have reasonable access. Can a hotel manager let the police into a hotel room? Yes, that's part of their business. A hotel room is not your is not your residence. However, an apartment owner or landlord cannot open an apartment room for the police because that is someone's place of residence and therefore not a public or open area. It's private. So those are all the ways to kind of look at is who has legal access versus the public and private space. So all of that is just going over what is a consent search, what is a warrantless search. And I hope this was interesting enough. I know it's just me talking for 15 or 20 minutes, but you'll spare, And as always, 2 dumb little videos for you. Later, guys.
I found a natural corn dog out in the wild. Let's taste it.